Recently, 6 MPs of Shiv Sena joined breakaway faction of Shiv Sena led by Eknath Shinde, and before this, 10 MPs of Aam Aadmi Party joined BJP and 20 MPs of TMC joined NCPI. This raises one serious question. What does our vote actually mean? If a person whom we elect joins completely different political party after winning election, and moreover, has India's anti-defection law lost its value? Let's understand in this video. Back in 1960s and 70s, defections became so common that governments started to collapse frequently. And the most famous was from Haryana, an MLA named Gayalal in the year 1967 changed multiple parties in the span of few days. And this led to famous phrase known as Ayaram Gayaram. So, to stop this defection, Parliament decided constitutional solution was necessary. And as a result, in the year 1985, the government led by Rajiv Gandhi introduced 52nd Constitutional Amendment Act. This was inserted as 10th schedule into our constitution. This is what we commonly call it as anti-defection law. The objective was simple: to prevent elected representatives from betraying the mandate of voters and to maintain political stability. Now, let's understand what this law states. It states that a member of Legislative Assembly or Parliament can be disqualified. Firstly, if a person or a minister gives up his membership. Interestingly, it is not necessary that minister has to give resignation. The conduct indicating that he has given up his membership is enough to disqualify a person or a minister. Secondly, if a minister votes or abstains from voting in a house contrary to the direction of political party, then he can be disqualified from that party, and this process is known as whip. Currently, this is hot political issue in the state of Karnataka as MLAs of BJP as well as JDS cross-voted to Congress for MLC election that was held recently. Thirdly, if an independent member joins any other political party after winning election, then he can be disqualified. And finally, if any nominated member joins political party after the prescribed time period, then he can also be disqualified. So, these are 4 situations where disqualification proceedings can be initiated, and generally it is Speaker or Chairperson of the House who takes the decision. Now, let's come to most controversial part of the Act. Earlier, when this Act was introduced, it allowed for smaller splits. That is, 1/3 members of political party can split and join some other political party. But this was heavily abused. So, in the year 2003, 91st Constitutional Amendment Act was introduced. It removed the protection given to 1/3 splits. And today, only merger is allowed. To that merger, 2/3 ministers of political party must support it. The idea was noble, because if 2/3 ministers decide to join different political party in the interest of the people or public, then they cannot be disqualified. But critics argue that it is biggest loophole of the act, because instead of preventing defection, it encouraged mass defection. Now, let's analyze what is problem with this exception or protection. Firstly, it breaches voters' trust. That is, most of us sometimes consider political party and vote for individual because we believe in political parties' manifestos, ideologies, developments, and promises, and we cast our vote to that individual. After winning election, if that minister joins different political party, then our vote has no value because the vote we cast to strengthen one political party has been used to strengthen the other political party. There, it breaches the voters' trust. And secondly, it may destabilize the government. Imagine a situation where a particular political party is holding power and 2/3 of its members join the different political party. Then the government collapses. This can lead to destabilizing the government, affecting overall conditions of the country. So, considering these two problems, critics have argued that the protection is biggest loophole of the act. And now, let me know your opinion in the comment box. Thank you.